Well, good morning. I'm Dan DeRose with 19 News Now. We're going to take you to a sentencing that is underway in Cleveland, the Cuyahoga County Court of Common Pleas. This is for the murder of a live-in girlfriend. James Drahos pleaded guilty last month to hitting his girlfriend, Tammy Duboison, age 56. He hit her in the driveway. She went unconscious. He left her body there for about 10 hours. When he went back out there to discover that she was dead, he wrapped her in construction trash bags and put her in a garbage can at the residence. It was then a couple of days later, and this all happened in Cleveland on the West 139th Street and Sherry Avenue, then took her body out of that trash can across the street to an elementary school and put that body in the dumpster. Let's take you live now to the sentencing, where we're probably going to hear from family members.
Well, so I had gone into the house because I wasn't able to get a hold of him either. So I went into the house.
You had access to the house? Okay. How old are you?
33.
Okay. So you're the adult daughter, and you're welcome there, yes? And so you wanted to see what you could see.
Yeah.
And what you saw led you to believe that what he had told you just wasn't the case, yes?
Mm-hmm. And I continued for a couple weeks before I made the missing persons report to reach out to family, friends, anybody that may have heard from her.
Did you confront him again during that couple of weeks? I see her things
yes.
are here. I don't believe she's in Indiana. Where is she?
Well, when I had questioned him again, because I had started to realize, I'm like, he hasn't once asked if I had heard from her at that point, which was suspicious to me. But I had asked once again where she was, and he said, oh, I think she ran off with someone from work, where she was working. And I told him, I don't believe that. She didn't like any of those people. She just went to work, did her job, came home.
Was that just a suggestion that maybe she was with somebody from work?
Mm-hmm. Okay. But at that point, I was still reaching out to everyone that, I knew she would talk to regularly. I was tracking her food stamp card at one point and seeing that it was being used, so I thought she was okay wherever she was. And when I had mentioned that to my dad, he said, oh, I've been the one using her card.
He was using her card even after she was deceased.
Yeah. But I thought, she was okay wherever she was because there was activity on her card. But once I realized he had been using her card, I immediately made the missing persons report because I knew something wasn't right at that point.
And then you were the one to discover some of your mother's remains. Yes. Could you explain to me how that happened?
So my best friend and I, we had all kind of had suspicions that something was wrong and that my mom was not okay. So we would do the buddy system anytime I would go to my dad's house. We had gone over there to make funeral arrangements for my grandmother, who had passed away on the 5th of July. And while we were there, she noticed teeth out in the driveway. She went outside to take a phone call from her father, and she had noticed teeth out in the driveway. I had stepped outside to smoke a cigarette, and she had called me over, and she pointed at the teeth on the ground, which I followed. There was a trail of them, which led to the side of the house, where we discovered the rest of the bones that we found.
Was she specifically looking?
She was just kind of pacing back and forth in the driveway while she was on the phone, and they were just right out in the open, right in the driveway.
And she recognized what those are.
Yeah.
And then what were your thoughts or feelings at that time when you saw that?
It kind of all just hit me. It sank in. With my mom being missing and not getting any clear answers, I pretty much knew deep down what we had just discovered was what I would have left of my mom, essentially. And if it wasn't my mom, that something happened to someone in that driveway. So we knew something wasn't right at that point.
And then what was your first interaction then with the police? Did they come out there at that time?
Yes, we called them to come and retrieve what we found. And I had my son with me. I called my fiance to come and get him just because I didn't want my son there, just in case anything happened.
And how old is your son?
At that point, he was 7 months.
I see. And so you waited there at the crime scene while they were
Yes.
processing the scene? Yellow tape and all of that?
So that didn't come until a couple days later, until they identified for sure that it was human remains. Detective Callahan and an FBI agent came to the house that I was living at the time and did the DNA swab and everything to match it when they did receive news that it was human remains that they found. And then that's when they received the search warrant to go to my parents' house.
And then your father wasn't there at the time?
He was there.
He was there at that time? Mm-hmm. And were you there at that time?
No. I was actually at the funeral home with my grandmother's remains. Like, my grandma was going to be cremated, so I was...
You were there on that day?
Yeah.
So there's a lot happening in your life with loss,
Yes.
compounded on top of each other. All right. There came a time when you and your father spoke, though?
Mm-hmm.
Okay.
We've
did you
continued.
confront him, or did he call you? Or how did that go?
When they did the search warrant, when they arrested him, he had called me later that night from jail and told me that he had been arrested. Pretty much told me, oh, you know, they caught me. I'm like, what do you mean? He's like, oh, you know, taking your mom out. And that was pretty much, you know, he's like, oh, you know, I'll be home soon. But we've stayed in contact through all of this.
Okay. And then he called you at some point from the jail?
Mm-hmm.
And he gave you a... did he talk to you initially about the pushing or how she
Yes.
initially, his first story?
Mm-hmm.
But then later he did speak to you, as Mr. Troop said?
Yes. Their house was broken into shortly after he was arrested. There were weapons left behind in the house after the search warrant, and everything was taken out of the house. But there were some weapons left behind. A couple of his guns were still at the house, and those were stolen. But when I had told him that their house was broken into and those items were stolen, that's when he changed his story and said that he had shot her by accident.
Because you were talking about the firearms and guns, yes. Did you tell him that's not what you told me the first time? Or?
Yeah, he went back to his original story at some point after that, which seems to be the story that he's sticking with.
Why would he tell you such a story about an accidental death with firearms while you were in this state of grief over your mother and your grandmother, if that weren't the truth?
I don't know if it's because he knew that the guns were stolen out of the house and they had no way to prove if that was how my mom actually passed away. It would be less of a charge for him at that point if that was the case.
If it wasn't involving a firearm, but rather his explanation of an accidental death.
Mm-hmm.
Okay. Okay. And were there any other contacts with him at all after that?
Yes, we've talked a few times within the last month or so, but before that, the last was in October.
And Mr. Troop, were some firearms taken out of the house during the initial search?
No firearms were recovered. It appears that they were located or stored in a place that simply was not discovered during the search warrant.
All right. But do you believe that the house was broken into and some firearms were taken afterwards?
Yes. There was a police report made when the house was broken into.
And that report, was it made by you?
Yes.
And then you said that there had been firearms in the house?
Yes. We knew there were firearms in the house prior to the search. I did let everyone, the detectives and everything, know that there were weapons in the house.
So they would have been on the lookout for them? Okay.
But when we received the list of items taken during the search, they were not listed on there, which leads me to believe they were still in the house at some point.
Okay, so I see. You're assuming that they would have still been in the house.
Yes.
But as Mr. True has advised the court, there were no weapons found within the house.
Yes.
So you had spoken to your father about how the house had been broken into,
Yes.
and your belief that weapons were taken from the house. So at that time, he might have thought that perhaps there were some weapons that perhaps the police had. But at some point in time, you realized that there were not.
Yes.
And then, Mr. Troop, it's the state's position, after speaking with law enforcement, that there were no guns in that house and that they would have been disposed of then by Mr. Dreyhus?
That's right. Certainly the opportunity exists that he could have disposed of weapons prior to the search warrant, but they did not recover any firearms from the search warrant.
All right. So I thank you for answering my questions. It kind of gives the court a fuller idea of everything that happened. And also perhaps, I know you've been speaking with Mr. Troop and also with the detectives, right? But knowing everything that happened, I hope it gives you some console, because at least you're not
Yes.
without the knowledge of that. You'll never know everything that did happen, though.
Yes.
And how are you doing now?
Comes and goes.
Okay.
Some
And then
days are
how
better.
old is your baby now?
He's 15 months now. And then I also have a 10-year-old.
Everybody healthy?
Yes.
Okay, very good. Thank you for being here. I appreciate
Thank you.
giving the court all of the information that you have. All right.
Thank you.
Thank you very much. Okay, Mr. Troop, anything further?
Nothing further, thank
All right, and what is the state's position again?
Your Honor, I firmly believe that the convictions here, the evidence that we have, certainly supports consecutive sentences in this case.
Okay, thank you very much. All right. Mr. Dreyhus, I'll now hear from your attorney, Mr. Kersey. Mr. Kersey, could you please provide the court with any
If you
mitigation?
want me to stay here at the table, we'll go to the lectern.
Why don't you stay there if
All right, thank
you're
you.
more comfortable?
I must tell you, Judge, mentioned before with you in the hallway that you and I, over the years, have had some very interesting cases. And I don't need to smile because we've had some real interesting, odd, and different cases involving murders. And for some reason, you and I get those cases together. And this certainly doesn't minimize anything that happened here, but it certainly is just, we must attract one another in that regard. Judge, I must say this.
Always been very professional, Mr.
Well,
Kersey.
thank you, Judge, but it's strange that we get those. Anyhow, Judge, what I have here is a 59-year-old man that has no prior criminal history whatsoever that I could determine. And I think that right from the beginning, when I've had thousands and thousands of clients over the 52 years I've been practicing, and usually they don't tell me the whole story, they don't recant stuff, and they don't really indicate, one, their guilt, and two, that they're remorseful. In this case, right from the beginning meeting him, he told me that he did this, and he's over and over told me that, and over he's told me that he misses Tammy. They were together 35 years or so. And I might also add that he's concerned about his daughter, and apparently they speak once a week and they get along. That's a good thing. So she said he is her father, even though he did these horrible things. Judge, we're also grateful to the state of Ohio for allowing him to plead to exactly what he did. And they reduced this to a voluntary manslaughter, and that's exactly what happened. I'm not going to go through what led to it, but apparently there was some kind of disagreement. He struck her. That's a felonious assault, any way you look at it. And as a result, the ensuing events and ensuing charges were created by him. Judge, he stepped up to the plate, as we say. He pled guilty to all these things that he's certainly guilty of. With me, he didn't try to minimize anything. I must say this, though, Judge. I'm also grateful to Dr. Stankowski, who I referred this young man out to doctor for psychological sanity, not because of competency, but mainly because of sanity, because of the weird and unusual and stretched, quote, facts that I was dealing with, what I'm dealing. The thing that underscores everything in here, and what I'm about to say isn't trying to justify anything. I don't do that. I think you know that. But what I'm about to say is what Dr. Stankowski believes, and I believe, occurred here. In summation, in her report, it's her opinion, to a reasonable degree of medical certainty, that the defendant was experiencing alcohol use disorder 5 and acute intoxication at the time of the alleged offense. That it's also her opinion that, with a reasonable degree of medical certainty, that the condition did not cause the defendant to know the wrongfulness of his acts. I'm not saying that. I'm only approaching that. Alcohol is exactly what happened. The drinking, he was an alcoholic, and it's in my way of thinking, this is a mitigation fact for the court to consider. And even the doctor agrees with that. Judge, I will say this, that he does speak with his daughter, as I've said, from time to time, and as a matter of fact, he's been gracious enough to not forestall her from getting his house. He's been cooperative in that. I prepared a power of attorney that they weren't able to use, and he was very willing to do that. He's very willing to sign a deed. I'm not going to get involved in a civil deeds with civil property law, because I don't do that. I don't do anything well, so I'm not about to get involved in that. But that she has a deed with her, and he's willing to sign that, Judge. So he's not disagreeing with his daughter in anything that happened. Judge, the other thing I'd like to ask you is this. He's not quite elderly. He's a middle-aged man approaching 60, so 59. There used to be in the Fed, when we have a sentencing, we can ask for a place that someone can go and the court can make a recommendation. Here it's a little different because of the Bureau of Prisons. Here the Department of Rehabilitation and Correction takes a different view of this. However, there was and I don't know if it's still in existence, down in Nelsonville in Hocking, Ohio, there was a prison down there, if the court so sees fit, to where there was elderly individuals who were ill and sick and sort of in his condition. And I would ask the court to, if Nelsonville, if it was called Nelsonville, if it's not available anymore, I'd ask the court to consider sending him to something where there's older, elderly, ill people, Judge. With that, I have nothing further to say, and I disagree with Mr. Troop's analysis that these should be consecutive. I think that some of these should be concurrent, and I trust the court to do it.
But not necessarily all of them, is what you're saying.
Yes, sir. That's correct.
Understood.
All right, Judge, thank you very much.
All right, Mr. Dreyhouse, this is your sentencing, so you have an opportunity to speak to the court. This is your constitutional right to speak to the court. Would you like to say something here, sir?
All right. You want me to stand here?
That would be best.
All right.
Do you have something prepared?
Well, it's footnotes.
Understood, sir. Go ahead and State whatever you wish to.
Well, I feel really bad about all this, honestly. I mean, if I had to do it all over, I'd change it all. And I really miss Tam a lot. Because if we did so much stuff together, we'd go walking in the park. We would do things like fishing down at Eddie's boat dock. We'd do other things too, camping once in a blue moon. We'd go out and have fun with that. And we'd cook in the kitchen a lot and bump into each other. I don't know, I wake up at night and I know she's not there, but at first I think I'm dreaming, you know, and this is all a nightmare. And it's hard to get over it. Sometimes I wake up sweating, feeling bad about it. And I really do feel bad about this because I only knew her, you know, and now I got nothing to go home to. It's like I tore up a street and I can't get back on that street to get home again. That's how I feel about it. I mean, that ruined everything. I don't feel good about it. Not at all. Mm-mm. It's horrible. And I had a lot of stuff I did because I was scared. I didn't know what to do. And, you know, being a little out of my mind there. And quite handle it too well, I would say. And I'd like to, you know, see my grandkids, Kyler and Giovanni, and see how they're doing and stuff. Spend time with Rachel. And it'd be pretty hard to do that when I don't know how long I'm going to live. I got arthritis bad in my feet. I'm taking Tylenol for that. And, I'm very sorry. Very, very sorry. I really miss her.
Well, you're talking an awful lot about yourself.
I do.
What happened there, Mr. Dreyos? Did you shoot her?
No.
Or did you strike her?
Striked her outside. She came outside and started yelling
Why?
at me because
Why in God's green earth would you tell your daughter that you miss and want to have a relationship with, that you actually shot her? Why would you say that?
I don't know. I was lost in my mind with a bunch of
Well,
stuff.
what were you thinking? That if I say I shot her and it was accidental, that I can get off of this thing and not be responsible for the pushing? I mean, I'm trying to understand your motivation there. I'm not saying you shot her, but I'm trying to understand. You're saying that you're remorseful. Why would you tell your daughter two different stories and leave her in the dark like this, first of all, for so long?
I really don't know, Your Honor.
If she and her friend hadn't found those teeth and the jawbone of the wife that you missed so much and did cooking with and bumped into and went camping and on walks for, why the hell would you not
I don't know.
say something to your own daughter who's in that misery? I mean, you want me to believe that you have some type of remorse for this.
I do.
But at the same time, your actions really belie that. I'm trying to understand your statements to your own daughter.
All right.
If you want to shed some light on that for me,
Well,
you
I was
can.
very confused during all this, and yes, I was drinking. So it does fog your mind a bit, you know.
Between an accidental shooting inside the house versus
Yeah, that's what I said.
a karate chop outside?
I didn't know. Oh, no, I didn't do that. We fought outside.
Was it a karate chop or?
I don't know karate, but I just said it, you know, because I don't know.
Well, you said that word to the police, right?
I know I did say that.
But it wasn't that?
No, it was a punch.
It was a punch. To what part of her body? How did you punch her? With your fist to where on her?
Probably in the nose area, I think.
Okay.
Because it's getting dark out. So,
Okay.
yeah. Somewhere in that area, but
And then
It all started because
she fell down? you think?
Yeah, she fell down. I thought she was just drunk, and I figured she'd get up and come back in the house.
Well, why did it all start? What was the argument that Mr.
It was
Kersey
all
was
about
referring to?
working, because I haven't been working. I put some applications in around and stuff, and then she was working at Minutemen on and off. And I worked there once, and they tell you it's only around the block, and then you end up walking miles, that kind of stuff. So I don't know. He called me useless and stuff like that, and started hitting on me. I was taking out the recycle, and then I swung at her, and that was that, I guess, because that's what happened. You know, she hit her head, obviously.
And is it true you went in and went to sleep?
I went in the house, watched TV, and I probably dozed off a little. But I thought she'd come back in, you know, and she woke up from all that drinking. They drank that vodka, like a Colonial Club or something like that.
You and her, you're saying?
No, I was drinking that Fireball, which is a cinnamon schnapps thing. And beer. We drank a lot of beer.
And where did you sleep that night?
I slept on the love seat.
Is that where you normally are?
Yeah, and she slept on the couch.
Okay. But she didn't return. But you didn't notice that until the next morning?
No, it was before that. It was in the middle of the night.
Middle of the night? And then did you
It was
look for her?
darker out. Yeah, I went and I put her in a garbage bag.
When did you do that?
That
At
same
nighttime?
night.
That same night.
And then I,
After you woke up?
yeah,
So are we talking now 10 o'clock, 12 o'clock?
maybe
2
about 10,
o'clock?
I'd say. It was dark.
Oh, it had just been getting
Put her
dark.
in there, and then later on, I was using Pine Sol double strength to keep the odor down. And at the end, I did not tear her apart. I just tried to take some teeth out and a bone broke. Because I figured if you see the teeth, you'll know it's her from the dental record, but that didn't work out. And I did not chop her apart. I put her in 2 bags. And I one over the top at the end, and then I had to lay the garbage can down at that time, you know. And then when I decided to take her and put her in the wagon, I just hoisted it, you know, the whole 2 bags at once.
How was she in 2 bags? How was she in 2 bags?
One was up to her waist and one was down to her waist from her head down.
And then how did that happen?
I put her in the bags.
So you had to somehow was it a skeleton at that time?
She had, half of her body was in the other bag, and that's been there since it happened, okay? And then,
But you had to have taken the body apart then, put it in 2 bags.
no, I did not.
They're 2 separate bags, yes.
Well, that was something else. That's some other garbage you must have got those pictures from. Because her remains went in one dumpster.
In 1 bag with another bag around it as well?
Over it, yeah.
Over it. So 2 bags, not 2 separate bags.
2 separate bags, one over her head to her waist, and the other one was the first bag that I had her in.
Okay.
Feet to the waist.
Did you take that up or? Okay.
No, they were big enough.
And then that happened when?
That, to haul her to some, I don't even know, it's so blitzed.
But it wasn't it wasn't that day, no?
Oh, no, it was about a month later, I guess, I don't know, somewhere in June.
All right. And so you had her in some type of a bin, I'm told?
Yeah, the black bin at a garbage can.
That's kept in the garage or outside on the side of the
Yeah,
house?
outside.
Outside of the house? On the side of the house, yes?
No, it's up towards the neighbor's garage.
Okay, all right.
It's up towards the house more.
And then you used Lysol at some point?
No, I used Pine Sol,
Pine Sol. Okay.
liquid Pine Sol.
And how much later did you do that?
So 2 or 3 weeks, because the smell was getting there, you know what I mean?
From where the bin was, about how far away is the bin from the house?
About, well, from the house to the bin, it'd be about 12 feet maybe.
Okay. And you had a bottle of Pine Sol laying around?
No, I went up to Family Dollar and bought 2 of the double times, the double strength. I bought 2 bottles.
Double strength.
And just used it every now and then when I needed it.
Did they have the regular strength there? Or
Um,
why did you get the double strength?
'Cause I don't know, I opened them up in the store and smelled them. Some of them didn't even smell like they'd clean your floor.
So you wanted something that would
Something stronger.
kind of hide the smell, right?
Yeah, that was it.
Okay. I appreciate your frankness on that. I've had to ask a lot of direct questions to get that from you, but
Yeah,
I mean, it's horrific.
I didn't dismember her.
Okay. Understood. Just wanted to dismember the teeth, so the teeth wouldn't be able to be.
Oh, yeah,
Right.
that didn't work out. I gave up on that. I was like, no, couldn't do it. Started to, and that's it.
Did you know you had left those behind? Probably not, right?
No, I didn't.
So when did that happen? The trying to take the teeth off? When you
That was-
put her in the bin, or when
No,
you
when I put her in the wagon.
put her in the wagon to take the wagon to the
I tried to
dumpster?
get the teeth out. I used a trowel and that didn't work.
A trowel, like a garden trowel?
Yeah.
To kind of dig them out?
Yeah, it didn't, yeah.
All right, and then you took it to the dumpster, yes?
But I don't know which dumpster.
But that same day, or no?
No, yeah.
And then when did you go back?
I waited until real late at night to go though.
That's a smart, probably right, because it's dark, nobody could see you. Is that why you did that?
Yeah.
Okay. And then when did you go back to the dumpster? Did you do that? Did you ever go back to the dumpster? Okay. All right.
I just said goodbye to her
Okay.
at the dumpster.
At the dumpster.
That's what I said.
Okay, sir. All right, thank you very much, sir. You may be seated. All right, the defendant has pled guilty to involuntary manslaughter. Count number 1 is amended. This is a felony of the first degree. At the time of your plea, sir, the court and you discussed the presumption of incarceration. Do you recall that, sir? Yes? Ellen? We talked about the prison time that you could receive. Yes? Do you recall that? Okay. And at that time, I had to explain to you the indefinite sentencing scheme here in Ohio. And I told you that I would do that again at the time of your sentencing as required. In front of you, then, is a form that you looked at and filled out. We went over it on the record, and I need to go through that with you again as to this felony of the first degree here. So do you see that, sir, and you recognize your signature? Yes? Mm-hmm. Okay, very good. Now, we talked about the very top of that, which explains to you whether or not you can receive any time off for behavior. I'll read that to you out loud again. The court has notified the defendant that pursuant to Revised Code 2929.19B2C, the offender is eligible for earned reduction of 5 to 15% of the minimum prison term imposed for exceptional conduct while incarcerated or adjustment to incarceration. And now, sir, I'm going to give you your notification for this indefinite sentencing scheme. As we talked about, for the felony of the first degree, you could get a sentence from the court of either 3, 4, 5, 6, 7, 8, 9, 10, or even 11 years at the maximum. And on the maximum side of the sentencing range for this indefinite sentence, you could then receive on this count alone an additional 5.5 years if the court gives you that maximum sentence. So I need to advise you then as to your notification here again. It is rebuttably presumed that the offender will be released from the service of the sentence on the expiration of the minimum prison term imposed as part of the sentence, or on the offender's presumptive earned early release date as defined in section 2967.271 of the revised code, whichever is earlier. Do you understand that, sir, or did you understand it at the time of your plea?
I'm trying to read it with you.
All right, let me go through that again. Do you remember how we went through all of this before?
Yeah.
Okay, let's make sure that we go back through that again. All right. Let's go through those words. Do you remember how I went through the words rebuttably presumed with you? Do you remember that? I'm at that first paragraph. Do you see it?
There, here, third here?
The first paragraph.
Oh, first.
That's what I'm reading to you right now.
Okay.
Okay? That it is rebuttably presumed. Okay? Remember those words that I read to you before? Mm-hmm. All right. Presumed means that it should happen. Remember how we went through that? Rebuttably means somebody can say something to the contrary and rebut that presumption. Do you recall all of that?
Yeah.
All right, let's go through that paragraph then. That it is rebuttably presumed that the offender, that would be you, Mr. Drehos, will be released from service of the sentence on the expiration of the minimum prison term imposed as part of the sentence, or on the offender's presumptive earned early release date as defined in section 2967.271 of the revised code, whichever is earlier. Did you understand that at the time of your plea, and did you understand it now? Mm-hmm. All right. Paragraph 2, that the Department of Rehabilitation and Correction, that means the prison system. Do you understand that, Mr. Drehos? Yes?
Yes, I do.
Okay. That the Department of Rehabilitation and Correction may rebut the presumption described in Division B2C1 of this section if at a hearing held under section 2967.271 of the revised code, the department makes specified determinations regarding the offender's conduct while confined, that would be your conduct while confined, comma, the offender's rehabilitation, comma, the offender's threat to society, comma, the offender's restrictive housing, if any, while confined, and the offender's security classification. Do you understand that paragraph, sir?
Yes.
And did you understand it at the time of your change of plea?
Good conduct.
All right, do you understand that, sir? Okay. So again, that all of those things they can consider, and they can hold a hearing, and they can keep you longer than the minimum term that the court gives you. Right? Do you remember this? Okay, I just want to make sure. And then paragraph 3, let's go over that again. That if, as described, Division B2C2 of this section, the department at the hearing makes the specified determinations and rebuts the presumption, the department may maintain the offender's incarceration after the expiration of that minimum term or after the presumptive earned early release date for the length of time the department determines to be reasonable, subject to the limitations specified in section 2967.271 of the revised code. Do you understand that, sir? Mm-hmm. All right. Paragraph 4, that the department may make the specified determinations and maintain the offender's incarceration under the provisions described in Division B2C1 and 2 of this section more than one time, subject to the limitations specified in section 2967.271 of the revised code. Do you understand that paragraph as well? Have you understood all of these at the time of your change of plea, sir? Okay. Paragraph 5, that if the offender has not been released prior to the expiration of the offender's maximum prison term imposed as part of the sentence, the offender must be released upon the expiration of that term. Do you understand all of that again?
Yes.
And did you understand it at the time of your change of plea, Mr. Drehos? Yes? Okay. All right.
Judge, if I may just say that I went over this before you did with David. I went through in detail and explained, particularly paragraph 2 in that. I explained to him at the side as I was talking to him, it's about bad conduct. when you're in the institution, is what it is.
Yeah. And in summary, we said the same thing at your change of plea, you said, Mr. Kersey. And then I went back to him to make sure that he understood paragraph 2, that it's about a number of factors. It boils down perhaps to bad conduct, but remember how we went over that. The department makes specified determinations, Mr. Drehos, regarding your conduct while confined, but also your offender's rehabilitation, right?
Yeah.
And also your threat to society, right? And also your restrictive housing in the prison system, if any, while confined, right?
Yes.
And then finally, your offender's security classification while you're there. Do you understand all of that, sir?
What is security?
Well, depends on your behavior there, and if they have to say, okay, this is an offender that we have to watch more. We discussed this at the time of your plea. Your security classification. You're not going in there as a low-level felon. You're going in there as somebody who's committed an involuntary manslaughter. So they have that risk determination, and they decide what your security level is. Do you understand that?
Yes.
Did you understand that at the time of your change of plea, too, when we went over it?
Yeah.
Okay, very good. All right, sir. Okay, prior to coming to the bench, I had the opportunity to review the entire case file. I've reviewed the pre-sentence investigation report. I've heard from the facts from the state of Ohio as well as from the defense as to the facts of the case as well. And I've reviewed the psychiatric reports again. The defendant had been found to be not only competent but also sane. And Mr. Kersey, thank you for bringing that again to the court's attention, because I had looked at that for any mitigation that was involved there as well. I've reviewed 2929.11 for the principles and purposes of sentencing, 2929.12 for the seriousness and recidivism factors, and 2929.13 and other revised code sections for felony sentencing. I've also reviewed 2929.21 for the misdemeanor sentence, the domestic violence that you pled guilty to as well. And the court has formulated the following decision based upon those overriding principles and purposes of felony sentencing, which are to protect the public from future crime by the defendant or others, and to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution. And I have considered the relevant sentencing guidelines provided, again, in revised codes 2929.11, 2929.12, 2929.13 through 2929.19. And looking at your pre-sentence investigation, sir, the court will note the Ohio Risk Assessment Summary, your recidivism risk level. You have 2 high scores in education, employment finance, as well as substance abuse, a medium score in family, social support, a lower score in criminal attitudes and peers. The facts of this case they are horrific. I can't imagine the hurt and the pain that family members and friends are going through who duped this person. But by all accounts, somebody who was faithful and loving and had a 35-year commitment to you and to her family, a daughter that loves her very much and searched for her, and must be very conflicted. But I truly appreciate the pain and the suffering that she and others are likely to go through, including your own grandchild that won't get to know her because of your actions. I don't know all what did happen, sir, but it is very clear that if it hadn't been for your anger, that she would not be dead. She'd be here with us. For this felony of the first degree involuntary manslaughter, sir, the court is giving you the maximum time of 11 years on the minimum side of the indefinite sentence. As we discussed before, your maximum side on that count alone will be determined by that sentence, which is 1/2, or in other words, 50% of that 11-year sentence, 5.5 years. So on that count alone, you're to receive an 11 to 16.5 year sentence. As to the offenses against the human corpse, commonly known as abuse of a corpse, felony of the 5th degree, the court will give you a sentence of 12 months on that. And as to the tampering with evidence, 2921.112, or the harm caused here on this, and your very callous disregard of the sanctity here of life and this body of somebody that you say that you loved. The court is giving you the maximum sentence there, 36 months. I'm going to run the abuse of a corpse concurrent, that 12-month sentence, with the involuntary manslaughter and the tampering with evidence charges. The domestic violence charge, misdemeanor of the 1st degree, by law will be run concurrent with all the sentences. That will be a 180-day sentence on that. As to that offense of tampering with evidence, a felony of the 3rd degree, the court is finding that that is a consecutive sentence. You must serve that sentence consecutively to the involuntary manslaughter sentence, sir. I've reviewed Revised Code 2929.14C4B, and the court makes the following finding. The court imposes prison terms consecutively, finding that the consecutive service is necessary to protect the public from future crime or to punish the defendant. That the consecutive sentences are not disproportionate to the seriousness of the defendant's conduct and to the danger the defendant poses to the public. And that at least 2 of the multiple offenses were committed in this case as part of 1 or more courses of conduct. And the harm caused by said multiple offenses was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of the defendant's conduct. And that truly is the case here for you, sir, because not only did you commit this homicide, but over a period of days and, in fact, weeks, you set out to hide the fact that you did do it. You tampered with the evidence, which could have shed more light on this and what, in fact, actually did happen. It could have shed more light for your family, the daughter, the community, but also to law enforcement. We have nothing to go on but your word, and I'm taking you as your word. I'm using that as mitigation in this, and I'm finding that the abuse of courts will be run concurrently, sir. But you certainly deserve this sentence consecutively, and that will be a sentence then of 3 years consecutive to that 11-year sentence, so that's 14 years, plus the 5.5 years as 1/2 or 50% of that 11 years. So you are looking at a 14 to 19.5 year sentence, sir, that you could be sentenced to. As to your post-release control, when you are released for this felony of the 1st degree, there's a mandatory minimum of 2 years up to a maximum of 5 years that you will be supervised by the adult parole authority. And for that felony of the 3rd degree, tampering with evidence, and the offenses against the human corpse, felony of the 5th degree, the adult parole authority could supervise you for a period of up to 2 years. It's at their discretion. As I read this to you at the time of your plea, I'll read it to you again. If you violate any post-release control rule or condition, you may be subjected to a more restrictive rule or condition, a longer duration under supervision, or you could be sent back to prison even though you've done all the time to which you have been sentenced. You could get up to 9 months in prison for each rule violation. The total, however, for all rule violations cannot be any more than 1/2 of the prison sentence that you receive, unless the rule violations for the commission of a new felony, in which case you could receive a prison term of the greater of 1 year, or the time remaining on post-release control, in addition to any time that you receive for the new felony. The post-release control prison term must be served consecutively to any prison term that you receive for the new felony. I don't think I've heard of a case, sir, where somebody has tampered with the evidence so many times. Had this been an offense that occurred perhaps all on one day, it would have been perhaps viewed differently in this court's eyes. But it does demean the seriousness of this offense if the court were to give anything different than this. I'm going to find you to be indigent at the request of your attorney, Mr. Kersey, and I will not levy any court costs or fines against you, sir. And I will give you the information that you do have a right to appeal your sentence. If you're unable to pay the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain counsel for an appeal, counsel will be appointed without cost. If you're unable to pay the cost of the documents necessary to appeal, such documents will be provided without cost, and you have a right to have a notice of appeal timely filed on your behalf. Is there anything further, Mr. Troop?
No, Your Honor, I think you covered it.
All right, thank you very much. Mr. Kersey, anything further?
Yeah, it's a thorough job. I appreciate the court doing that. If the court would make some sort of finding, recommendation where, again, where he could go, I'm not sure where they have elderly individuals that are sort of sickly.
First of all, Mr. Kersey, I don't find 59 years of age to be elderly.
I'm elder.
I won't ask you your age, sir, but I think it's north of 59.
82.
I didn't ask, I wouldn't have, but sir. More importantly, Mr. Dreyos, the court doesn't make that determination on what prison that you go to. You'll go to initially to the Lorraine Correctional. It's still Lorraine Correctional, isn't it, Mr. Troop?
Yes, it is.
And they make an assessment there. It's the same type of assessment regarding your risk and the security issues, as well as what you pled guilty to and been sentenced on. And they make those determinations as far as where the Department of Adult Rehabilitations and Corrections will house you. It might be in a place like Mr. Kersey suggests. It might be someplace else. And they also might sentence you to one place to begin with and then to another place. But they make all those determinations when you're down there and they evaluate you over at LCI. All right, sir? Mm-hmm. All right, thank you very much.
Dan DeRose with 19 News. As we watch James Drahos be sent to prison for at least 14 years, depending on his behavior, could be stretched to 19 years. We were given an immense amount of detail by the murderer himself about what he did to her body and just the incredibly heinous details of the fact that he punched her in the face in the driveway. She must have fallen, hit her head, died right there in the driveway. Hours later, he goes out, sees that she's dead, places her in 2 plastic bags, throws her in a garbage can. A couple of weeks goes by, the smell so bad that he uses Lysol or Pine Sol to try and cover up the smell. When he determines it's getting too bad, he comes to the realization he's going to have to throw her in the dumpster in the elementary school across the street. Keep in mind, this took place this past summer on West 139th Street and Sherry Avenue in Cleveland. Decides that he needs to put her in a wheelbarrow or a wagon to get her body over to the dumpster. And somewhere in that thought process, he thinks he better start pulling her teeth so that they can't identify her body. He says that he started pulling teeth using some sort of garden trowel. It was too difficult. Can't imagine the smell, let alone the fact this is a woman you were with for 35 years. He gets a couple of the teeth out, decides it's too hard, it's too painful, and so he stops and just dumps the body in the dumpster. It's those teeth that he left in the driveway that were found by her daughter, his daughter's friend, when she was on the phone pacing in the driveway when they had been looking for Tammy Duboisson. And as she's on the phone pacing in the driveway, she looks down and sees a couple of teeth. And that's when police were called, and that it was clear there was a crime that had been committed there. Just some absolutely disgusting details shared in court today. Because he entered into the plea deal, he wasn't hit with any kind of murder charge. He was charged with involuntary manslaughter, gross abuse of a corpse, tampering with evidence, and domestic violence. Could have been a total sentence of 11 plus 1, that's 12. There's 12, 15. It could have been 15 years, but instead the judge makes a couple of those counts concurrent instead of consecutive. He gets consecutive time on the tampering with evidence. The judge saying he had never heard of a body being abused twice by the same individual 2 weeks apart, trying to get rid of evidence of that murder. We'll have a complete wrap-up of this. Our 11 o'clock news is underway on CW43, then our noon news on Channel 19. Until then, I'm Dan DeRose with 19 News. Have a good afternoon.
19 News is everywhere. Download our CTV apps and follow us on social media @Cleveland 19 News.